Hello and a warm welcome to Federal's special program, Capital Beat. Modi government recently passed the 3 new criminal laws with an aim to overhaul the criminal justice system. Now, if you look at the 3 laws, what is the Indian Code becomes the Bharatiya Nyaya Samhita Bill. Then the Indian Evidence Act becomes Bharati Saksh Adhiniyam, that is BSA. CRPC becomes Bharati Nagrik Suraksha Samhita. Now, Amit Shah, when he was speaking in Lok Sabha, he said that the old British laws, they were meant to punish and not give justice to the people. He also said that there is a need to indigenize the laws. But if you look at the fine print of these 3 laws, the laws look harsher, they look far more draconian than the old British laws. So what do these 3 criminal laws mean for the common man? And how does it translate in the coming days? Joining me now is the renowned human rights lawyer of the country, Colin Gonsalves. Thank you so much, Colin, for joining on the Federal. And my first question to you is, and of course, we'll go one by one. And let's start with the IPC, that is the Bharatiya Nyaya Samhita. Now, the first question I would like to ask you is that, what was the idea behind changing the names to Hindi? Because many people say that it does alienate the people in the South to some extent. For them, it wouldn't be very comfortable. So, and Amit Shah also said that there is a need to indigenize. So is it indigenize or Sanskritize the names which were there? How do you look at it? And then we'll go on the, yeah.
Frankly, I think it is an attempt to obfuscate the law. Because even lawyers get puzzled now that the laws which are in English for all these decades is suddenly in Hindi. And in translation sometimes, because criminal law is very exact. You must write exactly what you mean to say. And so even in the legal fraternity, there is confusion as to meaning of the words, even in areas where Hindi is well understood.
Right.
Now, it may seem like a trivial thing, but it is not so trivial, because I think the real intention is to make the law so incomprehensible that Amit Shah will get away with his pet theory that the earlier laws were draconian and now we've done the nation a favor. The reverse is the truth, and is deliberately done in this way. The obfuscation is deliberate. And it is deliberately made to hide the doubly draconian provisions of the present statutes.
Right, right. So you very clearly put out that they are doubly more draconian than what anybody could conceive. Now, let's go one by one. And I would like to begin with IPC. Now, the Bharatiya Nyaya Samhita. Now, how does it really endanger the common man? Given the things which are there in IPC, and if we say that the laws are harsher, they are more draconian, so what are those provisions which one really needs to look out for?
Right. So now let me say this in a way and present the criticism in a way that an ordinary person watching your program will understand. Not in a legalistic way with this clause, this proviso, this subclause, and so on. I'll get to the heart of the matter.
Absolutely.
Now, the most important provision is that police custody under the earlier law was restricted to 15 days. You may keep a person in custody longer, but after 15 days, that person will be taken out of the lockout and sent to a jail. Torture takes place in the lockout. Torture normally doesn't take place in a jail. And in the lockout, it's a place of terror. So even the British understood this, that we must keep police custody down to a maximum of 15 days. And after 15 days of investigation, the judge must send the accused person to judicial custody. The present law permits a person to be kept in police custody for up to 90 days. And that is a shocking increase. Can you imagine a person in these cases, particularly where a person is a staunch critic of the government? 15 days was bad enough. and there were so many torture cases reported in that period, 90 days is an alarming increase in police custody. That's the first criticism. Shall I go to the second?
Yes, yes, right.
All right, now look at the UAPA provisions incorporated.
Just one query,
Yes.
Colin. You said that the police custody has been increased from 15 days to 90 days. Now, does it mean that the police will get additional discretionary powers? Anyways, we had a police Raj, and now are we heading towards that police Raj where they will have additional powers? Are we empowering them more than
Well,
before?
it's like this. If you say that you can keep him in your lockup,
Hmm.
you know how heinous and how deadly a lockout can be, where there are rooms at the back of the police station where torture happens on a routine basis. So now, instead of keeping him for a maximum of 15 days, you will keep him for 90 days.
Right.
It's a terrifying regime of torture. It's a terrifying regime of laws justifying torture. And the British period, so many judgments of our Supreme Court as well. After 15 days, he must get out and get into jail to prevent torture from happening. So this one provision is so draconian. I think it puts everything else into, into in a different light altogether. Now look at the terrorism provision.
Right.
Terrorism provisions are found in the Unlawful Activities Prevention Act. And the terrorism provisions, our country has said, our lawmakers have said, politicians have said, lawyers have said, judges have said, this is a draconian legislation. So the law as it is in the Unlawful Activity Prevention Act is draconian legislation.
Right.
For example, under normal laws, you will not be kept in custody. That is to say, police and judicial custody altogether, normally beyond the 90-day mark, and then you can ask for bail and all that. But under UAPA, that period of custody extends to 180 days. All right. Now let's see. It's a draconian legislation because the provisions for bail are enormously stringent and difficult to meet. Why are people in UAPA cases, all the cases that we know, the Bhima Koregaon and all these people, they are in for 5 years without bail?
Right.
Because there's a totally different bail provision, which makes it hard to get bail. Now, what do? They incorporate those provisions here in the present laws. But while doing so, they delete or they do not include two of the safeguards which Chidambaram explained to Parliament when he introduced the law. There was a clamor against UAPA, saying it's draconian, and our BJP friends were the ones who were clamoring, saying, oh, Mr. Chidambaram, you are bringing in a draconian legislation, to which Chidambaram said, well, it is a strict law, because to tackle terrorism, you need a strict law, but I am putting in two safeguards, which are very important safeguards. The first safeguard is sanction. After the police completes the investigation and is ready to file the charge sheet, the matter will be sent to the central government, and the central government will look at the evidence and say, should we sanction this prosecution? And the law is that if you don't get sanctioned, your prosecution comes to an end. First, very important safeguard. And who decides sanction? Not the police, but a government official.
Yeah.
The second important provision is that of the authority. The authority is an expert appointed by the government. And the expert will do the task again. You look at all the evidence and say, should I, after seeing the evidence that the IO has gathered, give a report saying the terrorism prosecution is justified? Both these provisions, both these safeguards have gone. Right. Which means you have a draconian legislation now without the safeguards. That is why I say this is doubly draconian.
Right. So which means that now they don't need the sanction of the central government.
No.
no permission from any authority. So whatever the police officer wants, he can really do it.
Correct. So let us say I had a fight with a member of parliament, or I called them a bloody fool or something like that. Sorry for the language. But I called them something, I used little rough language with them. That policeman can call up the local police station and get a terrorism prosecution. That's what they do, right?
So basically,
Kishore Chandra in Manipur
right,
used a foul term with his chief. That's all, a foul term. And in our law, it's not illegal to use bad language, let's say.
Right.
And he was in jail for a year.
So basically, terrorism has been brought under the ambit of the ordinary law.
Correct.
Activity now can be considered as a terrorist activity.
Correct. So the harshness is brought in,
right,
and the safeguards are thrown out.
Right.
So that's what our home minister is doing. And he says, the old is bad, the new is good, but the old was good, and the new is bad.
So what does it really mean for the common man? Like a journalist like me, or maybe a social activist, or somebody who doesn't like things of the government, he can be prosecuted under the terrorism case then.
Yeah, now I'm coming to that. This is closely linked with sedition.
Right.
Now, sedition, Supreme Court has stayed all prosecutions under sedition.
Right.
Why was it offensive? Why is there a hue and cry in the country? Because sedition prosecutes speech. If you're throwing a bomb or shooting a AK-47 or whatever, there are any number of statutes for that, and UAPA covers that. Engaging in violence to overawe the government and so on. So that's not the issue now. Sedition prosecuted speech. Under British law, if I said, I think the king should be thrown into the Atlantic Ocean, sedition, life sentence, speech. Now our government is not very different from the old English kings. Not very different. And they don't like any Indian citizen exercising freedom of speech and expression and saying things nasty about the government. Nasty means correct criticism. They don't like it. They're so sensitive, worse than the British, I would say, in terms of intolerance. So the old law said, whosoever by words. And then there are actions and this and that. We are concerned with these three critical words, whosoever by words. And then it says, brings the government into disrepute, hateful speech, etc., etc., etc. If you look at the new law, it has everything else, terrorism, violence, etc., etc., uprising against the government. But the beginning, whosoever by words. So the law which the Supreme Court has stayed is coming back in a new guise. The word sedition is not used in this new law, but the language is the same, whosoever by words. So if I say something hateful to the government, if I say something derogatory to the government, if I say that I express my hatred and everything, disenchantment, everything, and I point out to ministers doing this, that, and the other, you are in jail for sedition without calling it sedition.
Colin, from what you're saying, and if I've understood that correctly, which means that sedition is reborn as sedition plus, in fact, almost in a more vicious avatar.
Yes, it is. Yes, it is. Now see, why I say it's even more vicious. The Khalistan Zindabad case came to Supreme Court.
Right.
Now everyone, I suppose even you would probably think this is sedition.
Yeah.
Everyone, even the informed people in the country, think that this is sedition.
Right.
So when the case came from Punjab, Balbir Singh's case came to the Supreme Court said, this gentleman is accused of saying Khalistan Zindabad, my dear brothers and sisters, we must gather arms and get a homeland. I understand. But did he engage in any violence? Mr. Prosecutor, the prosecutor said, no, sir, no violence. What's the problem? What's the problem? If it's only speech, strong speech, distasteful speech, isn't that part of our freedom of speech and expression, Mr. Prosecutor? Case dismissed. And in the new law, words speaking of homeland, words speaking of separation is a terrorist offense. See, I can speak. It's part in the international law. It's the self-determination of nations. I can say, listen, there are communities sometimes inside countries that are ostracized, discriminated against, and say we want a separate land. Can you make that statement as long as you don't deal with violence? Can you make that statement lawful? Of course you can. The
Absolutely.
second case that came was the Azadi case from Kashmir.
Right.
Similarly, Azadi, Azadi, we must raise arms, raise an army, get Azadi. But then he went home and went to sleep. Didn't do anything. But he was arrested, taken, prosecuted, convicted. And when it came to the Supreme Court, what did he do apart from speech? What did he do? So reliance is actually I place on Rangarajan's case in the Supreme Court on freedom of speech and expression, where the Supreme Court said it is better to let a few noxious branches grow rather than stifle speech. Strong speech, intemperate speech, distasteful speech, everything comes under speech.
Oh, so
By
does,
freedom of speech.
which means, Colin, it's very clear that the government got in these laws with an idea to make the people realize that, look, the provisions are so stringent, so you better don't open your mouth, better don't express any sort of dissent, better don't say anything against the government, whether you are a journalist or a social activist or whosoever you are. Is that the clear idea?
Of course, without any doubt.
Hmm.
Don't allow any criticism against the government, against its policies, against its top people. No speech against them. It is as bad as, if not worse than, the British rule. You couldn't say in British rule that this king is an idiot. You couldn't say that. It's a perfectly normal speech. Working class people will say, our Raja, badmash, let's say. Can you imagine if somebody says that here in India today? I mean, you'll have the British police would come in and whisk them away and they'll disappear. You'll have that happening in India. That's why we say it's doubly draconian. He's out to stifle, he's out to crush free speech.
Look, that's very disappointing. But do you think that this is going to be challenged now in the higher court?
Yes, of course it will be challenged. Of course it will be challenged. But the
But
fact that he did it, and the worrying thing is misleading the people of India. I should say, actually, lying to the people of India. You're doing something draconian and you're saying that you're removing something draconian. I mean, how inventive with the truth. What a way for a senior minister of this government to speak in parliament. So you've misled parliament? Now there are people who are being put in jail for misleading parliament. I mean, come on, you're the captain of the ship almost. And you mislead parliament in this way, in this eloquent way. It's always done very eloquently, dramatically, eloquently, with such gusto. But the time has come to question all these things that are being said and done.
no, but what happens if you question? You would be booked under the case.
Nothing. I think none of these provisions will
Government
stand.
law. Now, since the fact that these laws have been passed, it's waiting for the presidential assent. But if in the meanwhile it's challenged, and if there is some kind of a stay, then of course there is a reprieve. But if the stay doesn't happen very quickly, then what happens? We keep criticizing the government, we question the government's policies, and what happens? There'll be cases against journalists, there'll be cases against social activists. What happens then?
Wherever, you're right. You're absolutely, from today onwards, from the president assent onwards, strong words used. This government is a foul and corrupt government. They are behaving in an anti-national way.
Yeah.
Suppose I want to say.
Hmm.
Ooh. Next minute, you'll be in handcuffs and you'll be in jail because the law has come and it's not yet stayed. See, journalists don't have to worry too much because the language they use is very correct kind of language. You all normally don't use ruffian language. But freedom of speech and expression is meant for the ordinary people who will express their things in not so polite ways as they are wont to do, and they have a right to do. They don't want to be diplomatic about what the government is doing to them. They want to be frank and outspoken and sometimes harsh. Even speech, Rangarajan's case, hateful to the government, is part of freedom of speech and expression. Hateful.
Right. You explained it quite well, the bit on the IPC. Now let's come to the Indian Evidence Act. And there are several concerns that, the material which is gathered as evidence, that is also a point of contention, that what is gathered as evidence could probably leave a very chilling experience. Your electronic material and all of that is going to be included. So could you just explain for the viewers now what it means and what are the points of concerns in the Indian Evidence Act?
See, the use of material taken from your mobile or your laptop and all that is actually in India a very, very weak point of Indian. Let's take search and seizures, where people come into a journalist's house and terrify his wife and children and grab the laptop as if it is their birthright to do these things. You see it in India all the time. And in the present, in the NewsClick case, you saw how they did it. Abroad, it's not like that. And Indian law needs to be changed, and we need to change the law. Abroad, if you're going to seize the laptop and mobile phones and these devices, you go to a judge and get permission. You go to a judge and explain why you need it. Because such seizure is so opposed to freedom of speech and expression that you can't just walk in and take it. And in India, you just walk in and take it. So we have to, that law continues even in the new laws. Grab. And the second thing is, once you grab, right, there's no actual legal procedure laid down for the grabbing and the taking and the recording and the seizure memos in terms of mobiles and so on and so forth. That is very, very weak. So this whole area of evidence, particularly electronic evidence, I tell you, it is taking you towards an emergency kind of situation. I think these laws are actually, when we say draconian, what does it mean? Because our government always talks about the Indira Gandhi emergency. And I do admit, the Indira Gandhi emergency was terrifying. But I think now we have a new, we'll not mention what it should be called, but we have a new emergency, which is perhaps 2-3 times more dangerous than the old. And the evidence and all this. And now the other thing, the courts have been very remiss. If you search and seize, contrary to the provisions of search and seizure, that is to say, it's an illegal search, it's an illegal seizure anywhere abroad, in any court abroad, that search and seizure will mean the end of the trial, the end of the investigation. You did something fundamentally wrong. Now we are closing your prosecution. But in India, Supreme Court, terrible judgment, really terrible. Search and seizure, even if illegal, is all right. You can use it in evidence. So then where is the drive to do search and seizure in India in a lawful manner? Let me take you to the FIR, if you don't mind.
Yeah, please.
Let me take you to the FIR. Now, citizens have had lots of problems. They go and make a complaint at the police station of rape or this or assault or cheating or whatever. And the policeman, if it relates to a very senior person, politician, government official, the police will tell you, all right, madam, I am putting your complaint in my register. I have another register for complaints. I'm putting your name. But I'll not register an FIR. I'll conduct a preliminary inquiry. Public are harassed throughout the country. Poor people are harassed, particularly when they complain against the powerful. So in Lalita Kumari's case, the Supreme Court said, stop this nonsense. Stop this preliminary inquiry. The moment you get a complaint which shows a cognizable offense, let's say a serious offense has been committed, immediately register. Same day, immediately without hurry, without fuss, not without fuss, immediately register. Without protest, police, register. So Lalita Kumari got over that harassment, preliminary, and preliminary inquiry can go on for a month, 2 months, 3 months, 4 months, and so on. It's an excuse not to register an FIR. Lalita Kumari said, register an FIR. What do the new laws say? Preliminary inquiry. They're going back against a 5-judge bench decision of the Supreme Court. They go back and say, we don't care for your judgment, Supreme Court judges, we don't care. We are going back to the preliminary inquiry. Then let me tell you one more thing, false cases, if you don't mind. In the Akshardham case, the Supreme Court acquitted all the accused after them being in jail for 5-6 years. And acquitting them, Justice Gopal Gowda, who wrote the judgment for the bench, said, we have gone through the evidence meticulously. And we are astonished that there's not a shred of evidence against the accused who have remained in jail for the last 6 years. This is an utterly false prosecution. Like this many. Nobody cares. Even our judiciary doesn't care. Okay, we acquit. How many years have passed? 7 years. What have you said in your judgment? No evidence. You acquit. That's it. You don't give heavy compensation. You don't order inquiry. You don't order a case to be made against the police who put this man in jail for 8 years, 7 years, poor person. And in the new bills, the punishment for a false case is 1,000 rupees. Can you imagine? Draconian means capital D.
Right.
Really draconian. And these are emergency type provisions.
Right. I'm just wondering that, these laws are reformed, these laws are changed in the name of the Constitution, that, we will try and refine the Constitution. What happens to the constitutional morality? Is the government really not worried about the constitutional morality? That what will these laws do to our own people?
I think Pratap Bhanu Mehta wrote in the Indian Express 3 days ago. I wonder if you've seen that.
Yeah.
What an article about the Supreme Court talking about constitutional morality day in and day out, but not doing anything to enforce constitutional morality. It is utter lawlessness. And when you see the parliamentary proceedings on these bills, utter lawlessness. That's what has happened. So when we say emergency, this is a new emergency. This is a new and even more dangerous emergency. We are not exaggerating. We are not making a big thing out of a small thing, a mountain out of a molehill. No. We are very much in the darkness of a new tunnel, the new darkness of a new emergency. But the new emergency, which is justified by winning elections. We won elections. If we won elections, who are you to tell us that we are draconian? The people are voting for us, so there's no draconian.
Absolutely.
Yeah.
No, but it's like one of the governors, ex-governors said, and I'm not taking the name here, that, the intention of the law is to just not let the people breathe.
Correct. The law as terror. See, when we say terrorism, we always, you're a terrorist, or you're a minority terrorist, you're an environmental terrorist. Now you're an NGO. These are the words used
Now,
by
law
this
has become
government.
a terror. The law has become a terror in
The
itself.
law as terror and the state as terror. It's very important. When terrorism emanates from the state, where the state is the fountainhead of terror, it is not the people as terrorists. People resisting terror are labeled as terrorists, but it is the state as terror.
Absolutely. So
And today, with all this Gaza thing happening, you can say, I won't mention it. It's very controversial. There are some states in the world that are terrorists.
Absolutely.
Their business is terror. They live on terror. They thrive on terror. Their commercial growth and their growth as a nation is based on terror. The state as terror and the Indian state now falls into that category of the state as terror.
You've explained the the contentious points very well, Colin. And my last question to you then would be that what do these laws then have done to the polity? Have we moved away from the democracy to an authoritarian rule? I mean, if you look at the law, what it does to the people, how will it translate? So, what else other than authoritarian? Is India moving towards an authoritarian rule then through these laws?
Yeah, there's no doubt about that. We are in a state of terrorism, of a different kind, of the state terrorism. Have we moved away from democracy towards authoritarianism, which is a mild word that you're using? Yes, we have. But what is even more dangerous is the abdication of the judiciary. Complete abdication of the judiciary for the enforcement of human rights. Almost a surrender, almost a collapse. Inability to stand up to the tyranny of the state. What was independence of the judiciary? That the moment the state becomes draconian, the judiciary will stand. But the judiciary has lost its spine. And the losing of the spine is not because the state is terrorizing them. Yes, they are. Judges' phones are being checked, your conversations are being monitored, your investigation into your son's accounts, your daughter's accounts, your wife's account. All this is happening. But it is also because judges at the highest level have betrayed their own institution. They rose to power on this edifice, magnificent edifice of the judiciary. And today they betray that. And they allow the government to destroy the institution.
But if you're saying that the judiciary seems to have completely abdicated, their responsibility, what happens if these laws are challenged in the court? What is the hope we have then? What if the judiciary doesn't say anything or takes a very nuanced position due to which the laws don't change too much? What happens then?
See, 2023 has been a landmark year where the Supreme Court has failed to act in at least 10 cases. 10 big cases. Now you're asking what will happen if this is what happens in 2024 and the senior most judges and the collegium judges are unable to gather courage to stand up and declare the laws illegal. We are doomed. As a nation, we are doomed. As a people, we are doomed. The rich will get richer. They are not doomed. But journalists like you, lawyers like me, ordinary people like workers, environmental activists, all those who are interested in keeping human rights alive in our country, they're all doomed. And it looks as if we are going into a very, very dark period of the kind even the emergency could not dream of. The Indira Gandhi emergency. We're going into that kind of darkness.
In fact, one of the editorials which I read on these three laws, and that was a line that, we are at a dawn that comes before the night of darkness. What would one say, really?
Yeah. And as a lawyer, I can see exactly what the judges are doing, exactly where they are failing, exactly where they're saying one thing and doing another, exactly where they pretend to be fighting and actually they are surrendering. And the judiciary now is a very big media unit. You must understand that. And so the spin, the moment the judgment is out, even before it's out, there's a kind of a, packaging of that case that comes out into the public. And that's very depressing to see. 23 has been our worst year. And 24, I don't know. I think it'll be even worse.
I really don't know what to say, but really feeling very, very disappointed. And especially after I've spoken to you, because now the picture becomes clearer as to what these laws look like and what they will do to the country. Thank you so much, Colin, for joining on The Federal. And one appeal to the viewers who are watching this interview, subscribe to our channel, send us your feedback, and stay tuned to The Federal. Thank you.
Subscribe to The Federal's YouTube page for more news and updates.